The United States has been a world leader in anti-money laundering enforcement. Money laundering is the financial engine that drives terrorism financing, tax evasion, human trafficking, bribery of foreign government officials, organized crime, drug trafficking, and evasion of international economic sanctions. In recent years, the U.S. government has collected billions of dollars from banks, companies, and individuals who launder money in furtherance of other criminal activity. Our primary anti-money laundering law has been the Bank Secrecy Act, passed by Congress in 1979. This law allows modest whistleblower rewards. Unfortunately, those rewards were capped at $150,000 and were completely discretionary. There were not a lot of protections for whistleblowers who suffered retaliation when stepping forward either. The net effect is very few anti-money laundering whistleblower rewards have been paid in recent years. For the rest of this video, we will refer to anti-money laundering by its popular acronym AML. The SEC and IRS have had their own whistleblower reward programs, but again, trying to get an AML whistleblower reward from these programs was often like trying to drive a square peg through a round hole. That is all changing. Hi, I am whistleblower attorney Brian Mahany, and in the next 4 minutes, we will tell you everything you need to know about the whistleblower reward provisions of the new Anti Money Laundering Act. New legislation will soon give anti-money laundering whistleblowers their own reward program. Called the Anti Money Laundering Act of 2020, the new legislation dramatically strengthens anti-retaliation provisions and allows the Justice Department to pay rewards of up to 30% of whatever is collected from wrongdoers. In recent years, we have seen some billion-dollar AML penalties, so we should soon see huge rewards. Here is everything you need to know. The new program is modeled off the SEC Whistleblower Program. Maximum rewards are capped at 30%. One flaw in the legislation is the lack of a minimum reward. The SEC, IRS, and CFTC all pay a minimum reward of 10%. We don't know if the new legislation will be amended or whether the Treasury Department will establish a minimum reward by rulemaking. Several existing federal laws already protect whistleblowers against retaliation, and the new Anti-Money Laundering Act of 2020 has its own protections. We especially like that it allows whistleblowers to report bank secrecy and AML violations anonymously. Like all existing whistleblower reward programs, earning an anti-money laundering whistleblower reward requires one to be the original source of information. That means having inside information that the government isn't already aware of. Almost anyone with inside information is eligible, including auditors and compliance officers. There are 3 groups of people who are not eligible for rewards. First, whistleblowers who were involved in the wrongdoing and convicted for their actions. Second, certain law enforcement and Treasury employees. And finally, those that do not follow the appropriate procedures. Like all existing whistleblower programs, there are many formalities in the process. We constantly hear from people who wrote a letter to an agency or called a hotline number and now wonder why they never received a reward. If you fail to follow the procedural rules, there are no rewards. There are no exceptions. Choosing the right whistleblower lawyer is therefore of critical importance. Although the Anti-Money Laundering Whistleblower Program is just rolling out, our whistleblower lawyers have been chasing banks for years. In the last decade alone, we have helped the government collect more than $16 billion from banks and financial institutions. And our bank whistleblower team includes former white-collar prosecutors, federal agents, and a top official from the SEC, Office of the Comptroller of the Currency, and the FDIC. Let us put all that experience to work for you. If you have information about violations of the Bank Secrecy Act, anti-money laundering violations, phony corporate books and records, violations of the federal securities laws, bribery of foreign government officials, terrorism financing, OFAC violations, or bank fraud, give us a call. Our contact information appears at the bottom of your screen. All inquiries are protected by the attorney-client privilege and completely confidential. Thank you very much for watching this video.